Hello and Assalamu alaikum to my fellow friends. As you guys are aware, we are now at week 11, which means that we will be the last group for this presentation. We hope that you guys will enjoy our presentation today and also you can gain knowledge by listening to it. So first, our group consists of 6 members, which was started by me first and then followed by other members. Okay, without wasting more time, we will present about sources of law, not the primary sources but the secondary sources of law. Now let us have a look at what's the real definition of the secondary sources of law. For the point of the general overview for the secondary sources of law, it is the cases and statutes establish the law, while secondary sources of law are background resources that explain, interpret, and analyze the law itself. Next, secondary sources provide commentary and background information on the law and can point you towards useful primary sources. However, secondary sources are not the law itself. Unlike primary legal sources, secondary sources are not generally not binding on the courts. For your information, secondary sources come in a variety of forms. They can include textbook, treatise, cases, journal, and periodicals, legal encyclopedia, and also dictionaries. Examples of secondary sources of law. There are many of it, which is Hansard, legal encyclopedia, legal dictionary, legal treatise, and legal periodicals. But now we will focus more on these 3. For the firstly, Hansard. What can we understand? Hansard was a traditional name of transcript on parliamentary debates in Britain and also in many Commonwealth countries. It is also known as the record debates in Parliament. For the background, it is named after Thomas Coulson Hansard, a London printer and publisher who was the first of the Parliament at Westminster. For next, we have Legal Encyclopedia. It is multi-volume sets that provide basic information on many topics of law. They are useful as a starting point for researching unfamiliar areas of law. It will arrange alphabetically by subject, which footnotes refer to each law, statutes, and regulation. For example, we have Handbook Law of England. And lastly, we have Legal Dictionary, which was provide definition of words in the legal sense or use. This publication also provides a short definition of foreign and Latin legal words phrase. For example, Oxford Dictionary of Law. Now we take a look at importance of it. That is, importance of secondary sources of law. Everything has its important, right? So that also apply on secondary sources of law. Now, secondary sources are important because they reflect how the law is being viewed. They provide insight into how courts are interpreting primary sources of law, like case law and statutes. First, they do this by offering valuable insight into recent court decision on new statutes. Second, considering implication of a new ruling. Third, examining topical legal trends or the current state of an area of the law. Without secondary sources, it would be difficult to get a picture of how the law is being viewed in a time, efficient, and straightforward manner. Okay, for today, our group will discuss about what can we identify as secondary sources of law. The first is that I will discuss later is the custom, and the second is books of authority, and lastly convention and treaties. So what are the custom? So custom are established pattern of behavior that can be objectively verified within a particular social setting. A claim can be carried out in defense of what has always been done and accepted by the law. It also, if followed from one generation to another, in the course of time, it acquires the character of law itself. Uncodifiedly, it is also known as living law. Customary law also consuetudinary or unofficial law exists, where first, a certain legal practice is observed, and second, the legal actors consider it to be the law. So that's all from me.
Okay, in secondary sources of law, have a custom in Federal Constitution, which is stated in Article 160(2) Federal Constitution, say that custom and usages having the force of law. Legal pluralism. What is legal pluralism? Legal pluralism is the Malaysian legal system consists primarily of secular codes drafted by legislative authorities. However, there are Sharia laws in Muslim on personal law matters enumerated in Constitution. In addition, the customs of the Malays and the people of Sabah and Sarawak are part of our law. At one time, the Chinese and Hindu customs were recognized in family law relations. However, the passage of the Law Reform Marriage and Divorce Act 1976 say that family law for non-Muslims has now been codified. Concept of legal pluralism, said by Norbert Rowland, he said that it is the multiplicity of forms of law preserved within any social field. While Jacques van der Linden said that legal pluralism is the existence within a particular society of different legal mechanisms applying to identical situations. By Griffiths also said that legal pluralism law is a law and legal institutions are not all subsummable within one system, but have their sources in the self-regulatory of all the multifarious social fields, present activities which may support, complement, ignore, and or frustrate one another. Legal pluralism also defined as the incorporation or recognition of customary law norms or institutions within state law, or to the independent coexistence of indigenous norms and institutions alongside state law, whether or not officially recognized. Okay, what are the customs in Malaysia? First is Malay customary law or adat. Secondly is non-Malay customary law, which is Chinese customary law and Hindu customary law. Thirdly is the customs of the orang asli in Malaysian Peninsula, and fourth is the native customs in Sabah and Sarawak. The characteristics of a valid custom. First is New Windsor Corporation of Vellore, 1975, 3 All ER 44, see that a valid custom is a good custom. In order to be valid, a custom must be from time immemorial, reasonable, and certain. Malay customary law divided by two parts, which is adat Temenggong and adat Pepatih. Okay, adat Pepatih is matriarchal customary law, which is embedded in written form in digest of customary law from Sungai Ujong, Perak, and Kuala Pilah. While adat Temenggong is patriarchal customary law, which can be found in Undang-Undang Melaka, Pahang Digest, Johor Digest, 99 Laws of Perak, Kedah Laws Digest.
Next, as we know, Malay customary law consists of two custom law, which is adat Pepatih and adat Temenggong. So I will explain more detail about it. Adat Pepatih applies in Negeri Sembilan and Nanning in Melaka. The unique characteristic of adat Pepatih is its matrilineal form of organization. It concerns with matters such as land tenure, lineage inheritance, and election of members of Lembaga and YDP. Matrilineal is a system in which one belongs to the mother's lineage. It generally involves the inheritance of property, names, title from mothers to daughters. Intertribal marriage is not allowed among adat Pepatih followers. Thus, punishment system in the laws of adat Pepatih generally aims to reform or rehabilitate the wrongdoer rather than retaliating against him. Political system in adat Pepatih is power in the family lies in the hands of the mamak, mother's elder brother. Then followed by mamak elects the buapak, head of subtribes. Also, buapak can elect the lembaga with tribal chiefs, and lembaga also can elect the undang territorial heads. Last, undang can elect the Yang Tuan Besar, ruler of state. Yang Tuan Besar must be from royal bloodline. Application on customary land in Negeri Sembilan and Melaka. On Article 90, special provisions relating to customary land in Negeri Sembilan, Melaka and Malay holdings in Terengganu. Nothing in this constitution shall affect the validity of any customary land in the state of Negeri Sembilan or the state of Melaka or any interest in such land. For example, in the case of Mona binti Haji Badar versus Isam bin Muhammad Said, in the case of land held by Naning Custom, Pepatih Custom, if pesaka land of a suku is registered under the name of a person not belonging to the tribe has vested right to redeem the land. Then we move to the second Malay customary law, which is Adat Temenggung. Adat Temenggung applies in other states. It is based on the characteristics of the patrilineal form of organization. Patrilineal is a system which one belongs to the father's lineage. It generally involves the inheritance of property, names or titles from fathers to sons. Marriage between those who come from the same tribe is allowed. Unlike Adat Pepatih, the laws in Adat Temenggung are harsh. Punishment is imposed as retribution. And the political system of Adat Temenggung, it is at the top is Sultan and followed by Bendahara, Prime Minister and Chief of War, and followed by Temenggung, Chief of Police and last Menteris. And we have also Adat Temenggung in Digest, which is Malacca Digest, Kedah Digest, Johor Digest and 99 Laws of Perak. Application of Temenggung customary law in harta sepencarian cases. First, we have harta sepencarian, jointly acquired property, Rama versus Alpha, 1923, Robert versus Umi Kalsum, 1963, and Boto versus Jaafar, 1985. The parties were married in 1966. Plaintiff wife worked as a coffee shop assistant and the defendant husband worked as a fishmonger in Dungun. During their marriage, the defendant bought the matrimonial home, a piece of land, 4 fishing boats, fishing nets and a fishing stall. The parties were divorced in 1974. The defendant only paid the plaintiff her maintenance after her iddah. The plaintiff applied to the High Court for a declaration that she was entitled to 1/2 share in all of the property acquired during her marriage. And the plaintiff applied to the High Court for a declaration that she was entitled to 1/2 share in all of the properties acquired during her marriage to the defendant and 1/2 share of all the income derived from their properties since their divorce. It helps of harta sepencarian is based on custom practice. According to the case, can be held. According to the case, can be held as harta sepencarian is based on custom practice by the Malays and rests upon the legal recognition of the part play by a divorced spouse in the acquisition of the relevant property and in improvements done to it, in case where it was acquired by the sole effort of one spouse only. It is due to this joint effort or joint labor that a divorced spouse is entitled to a share in the property. Then the share of 1/3 is awarded to the plaintiff because she had been helping with the plaintiff's business indirectly as a partner in his business trades. The incomes derived from the properties was divided into 1/3 and 2/3 shares. Last, we can look at the current practice of Adat Temenggung. First, harta sepencarian is based on Islamic law. Second, under the jurisdiction of Sharia courts. On Article 76, No law shall be made in pursuance of paragraph A of clause 1 with respect to any matters of Islamic law or the customs of the Malays or to any matters of native law or custom in the states of Sabah and Sarawak, and no bill for a law under the paragraph shall be introduced into either House of Parliament until the government of any state concerned has been consulted. So that's all for me. I'll pass my mic to the next panel.
Alright, next we have Chinese and Hindu customary law. Chinese and Hindu customary law were recognized but limited to family matters and inheritance only. These two types of customary law have lost their significance with introduction of the law reform, which is Marriage and Divorce Act 1976. Alright, now let's discuss about the Chinese customary law first. Alright, Chinese customary law were originating from Qing but modified, mixed English law and Chinese customs. Chinese practice of polygamous unions but has been abolished and replaced by the law reform, which is Marriage and Divorce Act 1976. The new law does not allow polygamous marriage, and all marriage must be solemnized by register with consent mutually. However, it can still celebrate marriage as per custom. Next, let's discuss about the Hindu customary law. Hindu customary law were adaptation from India but not necessarily the same as in India, provided it is not contradict to justice due to intolerable consequence, but religious marriage ceremony is valid.
Next, boost of authority. What mean boost of authority? Okay, boost of authority is a term used by legal writers to refer to a number of early legal textbooks that are accepted from the rule that textbooks and all books other than statute or law report are not treated as authorities. These books are treated by the courts as authoritative statements of the law as it was at the time at which they were written. They are treated as authoritative statements of the law as it is at the present time unless it is shown that the law has changed and may be cited and relied on in court as such.
So, I will move to the treaties and convention. Historically, treaties are the second source of international law. They were developed to give a particularity of rules of mutual conduct and then was provided by a custom. The word of conventions means treaty. It is an agreement made between two or more states or another subject of international law. As you can see in the slide, there are lots of categories of treaties, which is treaties, conventions, covenants, memoranda of understanding, exchange of letter, irrelevance of label, and bilateral, regional, and global, contractual, and lawmaking. Next is substantive and institutional. Next is self-executing and non-self-executing. Next is with vertical and horizontal effects. And last but not least, framework treaties and protocols. Hence, as what I mentioned earlier, convention is treaties that is sponsored by an international organization. So treaties and conventions address human rights, foreign aid, navigation, commerce, and settlement of disputes. Next, move on to the lawmaking treaties. Lawmaking treaties conducted between many states and creates general rules binding the states. So the example of lawmaking treaties is the Hague Convention of 1919 and 1970 on law on war and the neutrality. Next is the Geneva Protocol in 1925 on prohibited of weapons, and the last but not least is the Genocide Convention in 1948. That's all from us. Thank you.